As Neil said, my topic, which is in the abstract, was talking about can we rescue anti-discrimination law, can we return it to its original purpose of promoting participation in work, education, goods and services, rather than enforcing ideological conformity. However, although that would have been a fantastic paper, I've decided to pen that and talk mainly about the exposure draft legislation released by the Attorney-General last week, on which you have only until the 2nd of October to provide comments. So I will very briefly touch on what I was going to talk about and then go into more of an assessment of the religious discrimination bill, because that is one of the pressing issues, together with the other elements of the government's religious freedom agenda for religious freedom, freedom of thought, belief and conscience in this country. So anti-discrimination law works off a fairly simple moral intuition, which is that like cases should be treated alike. That was its genesis, and the idea being that a woman is as good at flying a plane as a man, so you shouldn't have sex discrimination in terms of pilots. And that was one of the first cases in Victoria under the anti-discrimination law against Red Jansett in the 1970s. Initially, it was addressed to race and gender as attributes. The only problem was that intuition by itself is not a sufficient explanation of how our society works. The reason it's not a sufficient explanation is that we value a range of other things besides that sort of formal equality, like cases being treated alike. We value, for example, rewarding effort and talent, which is discriminatory. We value giving people a leg up when they're disadvantaged, which is discriminatory. We see differences between things where we are meant on a formal equality basis not to see differences. So there is an assumption that gender was always irrelevant. Well, gender often is irrelevant to questions, but it's not always irrelevant. So if one of the genders is going to fall pregnant, it would be rational to bar that gender when pregnant from violent rides at theme parks, but not the other gender. That is a rational differentiation, even though it is discrimination. What all that leads us to is an understanding that when we say discrimination, although in the public and in the media, discrimination normally has a negative moral connotation, you're discriminating against me. Discrimination simply means to differentiate, and there is good discrimination and bad discrimination. There is reasonable and justifiable discrimination and unreasonable and unjustifiable discrimination. And until we get that in our heads and we say that to people when they say, isn't that discriminatory? Answer by saying, do you mean good discrimination or bad discrimination? And open up the question to what the other values are. When we started adding additional attributes to discrimination law, saying not only can you not discriminate against someone on the basis of their race or their gender, but you can't discriminate on the basis of their lawful sexual activity, or their political beliefs, or their religious beliefs or activities, or their gender identity, you've automatically included now a whole range of issues on which society, pluralist society, is divided. There are different political opinions, there are different moral opinions about what is appropriate sexual activity, there are different opinions about the nature of gender and gender identity. So now you've got a law which is trying to coerce a uniformity of treatment in relation to a particular attribute on a society which has a division of opinions about that attribute. And the big question for anti-discrimination law is, what reasonable accommodations does it make of those differences? It starts with a uniformity, a state-forced coercion of treatment, equal treatment, formal equal treatment in relation to those attributes. What, if any, allowances does it make for differences? Real differences, such as pregnant women, and differences of views in the case of attributes relating to political opinion, religious opinion, morality of sexual ethics and those sorts of things. And that's the key question, because at the moment in our debate we have not drilled down to that level of thinking about how anti-discrimination law needs to make reasonable accommodations. And the way it does it in practice, because the drafting was a very simplistic form of drafting, it says all differential treatment which is adverse on the basis of these attributes, gender, sex, whatever, race, is discrimination and is all presumptively unlawful unless there is an exception. And so it's the exception that takes things out of that big bucket of unlawful discrimination and puts them back on the right side. And the exceptions are things like Women and men can have separate sporting competitions. Women and men can have separate clubs. Women can be prohibited when pregnant from going on violent rides, etc., etc. And you can multiply those sort of exemptions across. The difficulty, the narrative which we have come to now is that some of the progressive people I should say that equality, formal equality, is the golden mean, it's nirvana, we must get there and we must have no exceptions. And the particular targeted exceptions in recent times have been those which have favoured people, usually religious people, and groups who have a particular moral view which is different to the current zeitgeist. So a different view of the morality of particular sexual conduct, or a different view about gender identity, etc., etc. And those exceptions, which are the things that make the Act work, are called a licence to discriminate. Well, there are many licences to discriminate in anti-discrimination law. Political parties have a licence to discriminate. They don't have to employ people who don't agree with them. You may have noticed that the Liberal Party is not very diverse, or the Labor Party, or the Greens Party. You may have noticed, if you live in South Australia, that you can have a club just for people of a particular gender identity, except for heterosexual gender identity. So there are exceptions, and it's the exceptions that make these the sort of starting position of formal equality work in the real world. So is there a way of getting back? Some people say junk anti-discrimination law. I don't think we should junk it. I think it does a very important thing, which is to provide access to goods, services, education and facilities for people who would otherwise be excluded through prejudice or bigotry. But where it has gone wrong is reaching into, I think, these sort of ideological areas and becoming an ideological weapon to shut down competing views. So how would we think about it doing better? Just a few points, high-level points. Number one, define what constitutes prohibited discrimination carefully. Disagreement is not discrimination. Disagreement is not discrimination. In general, speech should not amount to discrimination, and anti-discrimination law should not apply to the expression of ideas. Secondly, we should focus on real harms, real exclusion from options to participate in a facility or a service or a benefit in society, and we should not be focusing on offence or dignitary harms. That is, I'm offended, I'm insulted, I'm emotionally hurt by what you have just said. We need to carefully interrogate asserted harms to see if they are substantiated by evidence. There were proposals in both Victoria and Queensland to not allow primary school students to take religious texts into classrooms. This was because it would create a, quote, unsafe space, end quote, for students who were not religious. And in Queensland they even said it would go to banning Christian-themed Christmas cards. Truly. Now, there's no evidence of that. It's just an assertion. So we need to interrogate those harm arguments carefully. Sometimes there is harm, but you need to interrogate those arguments very carefully to see if there is harm behind them. And finally, my approach to this is to try to seek to maximise all interests. Where possible, look for a win-win by promoting a reasonable accommodation which permits different people and groups to seek and live by their own conception of the good, provided nobody is being practically excluded from all options to participate in a facility or a service or a benefit. Let me give you an example. Catholic adoption charities in Victoria would prefer to adopt to heterosexual married couples, or foster to heterosexual married couples, and not to same-sex couples. There were other agencies in Victoria which would merrily adopt to anybody. So no same-sex couple ever missed out on being able to have a foster child or an adopted child, but they wouldn't have got it through a Catholic charity. Question: in our society, do we accommodate that difference of the Catholic charities and let them operate by their lights, given that no gay couple will miss out because others will provide that service? Or do we say, no, we must have acceptance of this particular ideological view that nobody is to be treated differently on the grounds of their sexuality or their relationship status across the board, which of course ends up discriminating against Catholic adoption agencies, Catholic relinquishing mothers and so on. So my view, and that's sort of an example, is you go for accommodation. If no one is going to be hurt, in the sense that no one is going to be deprived of the opportunity to participate in fostering and adoption services, why not have multiple different ones living according to different lights? Okay, that's the speech I didn't give. So let's move on to the one that I said I would. that little intro will be relevant because we're going to talk about discrimination in a fair amount of detail. This is recap stuff. Our freedoms of religion protections are strong in international law, but weak in our domestic Australian law. So many of you in the room, I know, will be familiar with all of this, but for those who aren't, Article 18 of the International Covenant on Civil and Political Rights says, to which Australia is a party, says that everyone has the right to freedom of thought, conscience and religion, and freedom to have or adopt and change their religion or belief. Everyone has the freedom to manifest their religion or belief individually or in community with others, in private or in public, in worship, practice and teaching. Worship, observance, practice and teaching. Now that right is subject to exceptions in 18.3, which says restrictions which are imposed by law, as statute or a bylaw or a regulation, and those restrictions must be necessary, not reasonable, but necessary to protect public order, health, safety, morals, and the fundamental freedoms of others. There are 5 categories of permitted exception in international law. Now that's international law, it's not Australian law. Australian domestic law does not strongly protect freedom of religion, even Section 116 of our Constitution. And I think, there are plenty of people who know more about that than me in the room. Where is freedom of religion protected in Australian law? It's mainly in anti-discrimination statutes, and it arises in 2 ways. First of all, discrimination against people on the basis of their religious belief or activity is unlawful in 4 states and 2 territories. It's prohibited in the Anti-Discrimination Acts in Victoria, Queensland, West Australia, Tasmania, Northern Territory and the ACT, but it's not unlawful to discriminate against someone on the grounds of their religion in federal law, in the federal anti-discrimination laws, in New South Wales or in South Australia, subject to religious dress in South Australia. So Israel Folau had no anti-discrimination rights under New South Wales law, for instance, where his contract was. But even where it is unlawful, in those 4 states and 2 territories, there are exemptions, so anything authorised by statute. Remember I said that exemptions are the balancing provisions. There are 2 types of discrimination: direct discrimination, where I just treat you individually in a less favourable fashion on the basis of a particular attribute, your race, your gender, your religious belief. And there's indirect discrimination, where I or someone has a general condition or policy or practice which applies across the board, but which disadvantages people with that attribute more than others. Now, indirect discrimination is quite common because you think of all the different employer codes of conduct or workplace codes of conduct or gym codes of conduct. They're all rules, practices, conditions of general application. If they land more heavily on people with a particular attribute, that's a form of indirect discrimination. Indirect discrimination is not unlawful if it's reasonable. So if the code of conduct is reasonable, then it is justifiable and it's not unlawful. So even though discrimination against individuals is unlawful in those 4 states and 2 territories, if it is in the form of indirect discrimination, and the indirect discrimination, the general policy, is reasonable, and there's a set of factors for a court or a tribunal to work that out, it's not unlawful. So it's not as clear as it looks. The main place where religious freedom is protected is actually still in anti-discrimination laws, but in the reverse situation. It's in exemptions. There are exemptions in most, not all, anti-discrimination laws at state and territory level and federal level for religious bodies and religious education institutions. And this is in relation to discrimination on the grounds of, say, gender or sexual orientation or gender identity or other matters like that. So if you are a body formed for a religious purpose and you are acting in a way which is in conformity with the doctrines, tenets or beliefs of your religion, then that is an exemption from the Sex Discrimination Act, from discrimination on the grounds of gender identity, sexual orientation, gender, age, etc., etc. So they're the protections which Christian schools, Christian bodies and other religious schools and other religious bodies rely on. And that is the main place where we have any statutory protection for freedom of religion in Australia, and that is the main place where pressure is brought to remove those exemptions or to modify them. That's the current situation. Okay, let's do a quick recap. We had the same-sex marriage postal vote. It raised concerns about freedom to act or express on a traditional view of marriage and family if same-sex marriage became law. Both the Prime Minister and the opposition leader said, don't worry, we believe in religious freedom even more than we believe in same-sex marriage. Trust us and vote yes. So we trusted them and voted yes, and they both did nothing about it. Coalition backbenchers put together various amendments to secure freedoms in those bills. The Coalition had a conscience vote. The majority of the Coalition voted for those freedom amendments. The ALP did not have a conscience vote and voted against them. All those amendments were lost. The Prime Minister said, look, don't worry about it. Let's pass same-sex marriage now and we'll have an inquiry, the review, which became the Ruddock Review, into freedom of religion. Now, you might notice that the issue in same-sex marriage was accommodating people who had traditional views about marriage. It's now been expanded massively into freedom of religion, but okay. So the Ruddock inquiry runs from January to May 2018. The government then sits on the report. Silence until it's leaked, and the ALP forces a government response by bringing in a bill to get rid of all of the exemptions for religious education institutions and indeed the education practices of churches, mosques and synagogues, the Wong Bill and the prior Greens Bill. And the government says, oh, we can go with some of that but not all of it. And the whole thing is in a terrible state in the febrile parliamentary conditions of December last year, and we almost lost all of those protections. 2 Centre Alliance senators refused to move as far as the ALP wanted to go, and so those bills were blocked. The Morrison government said, we'll take out those exceptions, but we'll put something else in, like religious schools can teach in accordance with their faith. Now, the Ruddock Review had actually said, keep all of the exemptions. The government's own review had said, keep all of the exemptions, but make them transparent. Schools must tell prospective parents and students what the deal is, but keep the exemptions. Because of a great political attack that happened in November, all of those exemptions are now on the chopping block, with some possible replacement. So Prime Minister Morrison repeated the government's promises of religious freedom in May and won the election partly based on religious social conservatives' support. And there are notable swings to the ALP across various issues by religious voters. So the government has said we'll implement some of the Ruddock Committee recommendations and some additional things. So here's their agenda. First off is the Religious Discrimination Bill, the exposure draft of which was released last week. There also, accompanying bill, amendments to the Charities Act regarding traditional marriage beliefs, and some provisions about religious school facilities and objects clauses in statutes. I'm going to look at those. A provision to override low-bar insult or offend provisions in Section 17 of the Tasmanian Anti-Discrimination Act, and the government's even gone further on that in a surprising positive move. Put in a Religious Freedom Commissioner to the Australian Human Rights Commissioner. That wasn't recommended by Ruddock, but the government's going to do it. It was recommended by Freedom for Faith. Legislation based on the ALRC report on how to remove those exemptions which protect religious schools and religious bodies, not just religious schools, but churches, mosques and synagogues from other anti-discrimination law for like the Sex Discrimination Act, has been referred to the ALRC, and we'll hear this afternoon from Justice Sarah Derrington, who is the President of the ALRC. While still letting those sort of bodies manage their affairs in accordance with their faith. There are other bits tucked away in there. Giving parents the right to take their children out of classes which teach material opposed to the religious or moral framework of home. At this stage, the government simply proposed model guidelines which will be negotiated with the states. I would not like to be the person who tries to ask Daniel Andrews to implement model guidelines in Victoria. I don't think they'll be effective if they're just model guidelines. What is missing? A Religious Freedom Act to protect against government interference with religion. So Religious Discrimination Act will go through, no general Religious Freedom Act. That could be expressed as positive rights or negative, I don't care about that, but protecting against government interference with religion, not on the agenda at the moment. And missing, a right not to be coerced to speak or act against one's conscience or religious beliefs. Not there. Okay. There are 2 main bills that have come out. One's the Religious Discrimination Bill, and this is the Human Rights Legislation Amendment Freedom of Religion Bill. And this deals with the charities point and other points. Okay. So, objects clauses. The Ruddock panel said objects clauses in the Anti-Discrimination Act should respect the equal status in international human rights law of all human rights, including religious freedom. This is because in some cases religious freedom had been sort of downgraded versus the right not to be discriminated against on the basis of other attributes. And the Ruddock report said, no, we need a statement that all human rights, including freedom of religion, are equal. Well, the drafting in this bill doesn't quite get there. It amends objects clauses of various acts and says to the courts, when you're interpreting an Anti-discrimination Act, regard is to be had to the indivisibility and universality of human rights. Okay, that's good, it's true. It's not quite clear that it says exactly what Ruddock said, which is treat all human rights equally. Why they couldn't just say that, I don't know. Secondly, the Ruddock recommended, and the government also committed to reference the Syracuse principles about religious freedom, which is that it has to be necessary, when you're interpreting a law, it has to be a necessary limitation on religious freedom, and no lesser restriction would have sufficed to achieve the goal. We haven't seen anything like that come out of the government. This bill permits educational institutions established for religious purpose to refuse to make facilities available for the solemnisation of a same-sex marriage if that would be contrary to the religion of the school. That's a good provision. And then we've got the charities amendments. So the English Charities Commission denied charity status to 19 Catholic adoption charities because they preferenced married hetero couples over other couples. And the Charities Commission, upheld by the High Court, said that's contrary to law and public policy, which means that you've got an unlawful objective, which means it's not a charitable objective, which means you've lost your charitable status. So all 19 lost their charitable status, and they either closed down or were sold to private operators. I think that's a public policy train wreck for reasons I explained before. Why would you take 19 adoption agencies out when no gay couple in England was unable to adopt or receive a foster child? Because there were plenty of other adoption and fostering agencies which would do that. This bill will amend the Charities Act, Section 11, to provide that engaging in or promoting activities that support a view of marriage as a union of a man or a woman to the exclusion of all others is not of itself a disqualifying purpose in terms of that English decision. Now, that amendment to Section 11 is a good provision, but you might ask the question, and it was what was recommended by Ruddock, but there is a question, should that now be extended to cover some other points where traditional religious morality is now conflicting with legal rights in some jurisdictions. So Tasmania and Victoria, and I think one other jurisdiction, have legislated to say you can change your gender by changing your birth certificate without hormonal treatment, without diagnosis of gender dysphoria, without any surgery or anything like that. So now I present as a woman because I've made the declaration, I've had my birth certificate changed, and I run into a religious body which says, well, sorry, we're actually not going to treat you as a woman because you don't appear, I mean, you self-identify that way, but you don't appear that way. And that could come up in a whole range of different aspects. Will we now have the case where a religious charity is said to be operating on a basis which is an unlawful purpose because it's contrary to public policy in Victoria and Tasmania and other places? And so you can multiply those out. So if we're going to do this, do we do it just for the beliefs about marriage, or do we do it about some other obvious beliefs which are going to cause the next case? Secondly, when we do this, we also need to change, and the bill does not change Section 6 of the Charities Act. So Section 6 requires that a charity's purpose must be for the public benefit. That's separate to the disqualifying purpose of unlawful or not in accordance with public policy. Section 6 says must be for a public benefit. And the New Zealand High Court has deregistered a lobby organisation, a Christian lobby organisation over there, on the basis that its goal of promoting the traditional family unit and man-woman marriage, if achieved, would not, in the opinion of the court, be a public benefit, and therefore that goal is not charitable. So this is a lawyer's detail issue, but it is of significance. It is of significance for charities. It is of significance for whether or not organisations, some of which are represented in this room, can continue to have charitable status. All right, let me jump to the Religious Discrimination Bill. It's out for consultation until the 2nd of October. I must say it's a startlingly short amount of time to consult on it. It was released last week and the Attorney-General's meeting people in Melbourne today and Sydney tomorrow. Anyway, the broad idea is you can't discriminate on the basis of someone's religious belief or lawful religious activity. I have a few questions. What is religious activity? On prayer, baptism, sacraments, maybe proselytising. Does it include stating a religious view of gender in a tea room? Is that a religious activity? Because that's the sort of thing people will get pinged for. Is religious activity broad enough, or does it need some additional expansion, as in those same-sex marriage amendments, to say conduct which is reasonably and genuinely believed by the adherent to be flowing on from the religious belief? We don't want too narrow a definition of the protected activity. And then lawful. It has to be a lawful religious activity. Can a state law or a council bylaw readily make an activity unlawful, thus removing federal discrimination protection for it? So, gender conversion therapy will probably be made unlawful in Victoria, and if it is defined to include any counselling against homosexual tendencies or praying for people in that regard, that would then become an unlawful activity, and you would be subject to being complained about for discrimination, and you wouldn't get the protection of the Religious Discrimination Bill because your activity would be unlawful. We have an MP in Victoria, Fiona Patten, formerly of the Sex Party, now of the Reason Party, who has just proposed to expand our Racial and Religious Tolerance Act into an Anti-vilification Act, make it unlawful on social media or anywhere else to engage in vilification on the grounds of gender, gender identity, sexual orientation, a whole range of things like that. Now, we're going to come to that broad word vilify in a moment, but you put out a comment like Israel Folau, or something milder, you fall into that act, it's unlawful, you're discriminated against by your employer or someone else on that basis, no protection here because your activity was not lawful. So we need to look very carefully at what lawful means. I think lawful should be restricted to something which is illegal under the general criminal law. Statements of belief are protected, so that this is a good feature of this bill. It is protected in two places, in the Israel Folau clause, which is clause 8, and in the Porteous clause, clause 41. And they're protected when you make a statement of belief. You're protected from it does not constitute discrimination under anti-discrimination law, and it's not unlawful under section 17 of the Tasmanian Anti-Discrimination Act, which is the section under which complaints were brought against Bishop Porteous and 2 other Christian ministers. These are promising provisions, and I commend the government for including them, but the detail in them currently undermines their effect. There is no protection under clause 41 from employer discipline or sacking. Remember, this 41 just says it's not discrimination, you can't bring a discrimination complaint about it. The protection from under section 8 turns on the reasonableness of the employer's policy. To qualify as a statement of belief, the statement must not be malicious, fair enough, and it must not harass or vilify or incite hatred or violence against another person or group of persons that are not protected. I have no problem with any of those words, except question what does harass or vilify mean. So I agree, there should be no protection for statements which incite hatred or violence or which are malicious. But could someone tell me what vilify means? It's an interesting thing, but I think in all, and perhaps most, there's certainly most, but I think all anti-vilification laws, the verb vilify is not used. So in Victoria we have an anti-vilification provision which says you cannot hold up to severe ridicule, harass, intimidate, etc., a person on the grounds of an attribute, but the word vilify is not used. We've used the word vilify in this bill. Was Israel Folau vilifying people? We at least have a court case or several court cases to work that out, don't we? I think the word vilify either should be removed or should be defined very clearly in line with what's in the state laws. Otherwise, this just undermines the whole thing. The relevant statements of belief that are going to be problematic here will be contested. They will be controversial. They will be said to vilify. We need a clear definition of which are in and which are out for the purposes of this anti-discrimination law protection. Lastly, the definition of statement of belief provides that the statement must be reasonably regarded as being in accordance with the doctrines, tenets or beliefs or teachings of religion. So if you're going to make a statement of belief, it has to have relation to your religion. Who decides that? Well, it's a tribunal member or a judge. And the test is they have to be reasonably regarded, the statement has to be reasonably regarded as being in accordance with the doctrines. Well, do you see the problem there? So Israel Folau says this is what I think 1 Corinthians 6:9 means. Do we now have a tribunal member at the AHRC or a judge saying, well, let me get evidence from 6 different theologians. What's your view of 1 Corinthians 6:9? This will be a good work scheme for academic theologians finally coming into their own, but not very helpful for religious people. Okay? And are we seriously asking a secular court or a secular tribunal to say, well, on our best view, this is the meaning of your belief, and what you've stated is not in accordance with your belief, or I cannot reasonably regard it? Surely we don't want judges and tribunal members getting into reasonable assessment or assessments of the reasonableness of belief. Would we not be better off just saying having a test of the genuineness of the belief? And then we already strip out the beliefs we don't want to protect later by taking out the malicious, inciting violence and hatred and harassing ones. That's where we edit out the bad beliefs. We don't edit it out at the point of whether or not a judge thinks they bear a reasonable relationship to doctrine. So let's just go with a test of genuineness there. Statement has to be in good faith. I'm not quite sure what that means. Was Israel Folau, he might have been making his statement in good faith. I'm not sure. It's not clear that corporations will be protected from religious discrimination. Now, why is that important? That's important because a lot of churches are incorporated entities. So the Secretary of the Baptist Church, which is an incorporated entity, wants to book the hall for its meetings. And it says, no, we're not booking a hall to you, you're Christian. That's not discriminating against the Secretary, it's discriminating against Baptist Church of XYZ Incorporated. Does it have a right to be protected from discrimination? Well, sort of, because the bill says persons include, under the Acts Interpretation Act, corporations. But that's like being half pregnant, because when that gets to court, the court's going to say, hang on, there's case law saying corporations can't have religious beliefs. What do you mean this corporation's got a religious belief? How do I know that? So you need to put provisions in, you need to make it crystal clear that a corporation can have a religious belief, and this is how you evidence it. That needs to go in. We've made that submission to the Attorney General, but so far it's fallen on deaf ears. There are private corporations. Why should a private corporation run by religious people on religious bases be subject to discrimination? Well, this is not about whether they can discriminate against anyone. This is about whether they can be discriminated against in terms of a boycott or something like that. White Magazine, Hobby Lobby in the US, Chick-fil-A. Chick-fil-A does apparently great chicken sandwiches. I've never had them. But their CEO came out against same-sex marriage. Massive boycotts. University said you have to get out of here, you can't have your franchise here. Local government said we're not giving you planning permission for your franchise here. It was discrimination against them on the basis of the religious views of their employer. They suffered damage. Shouldn't a corporation, a small business run by religious people on religious grounds, be protected from discrimination, that is the corporate entity, the trading vehicle, be protected from discrimination on the basis of the religious beliefs and operations of the owner? Otherwise you leave a big hole. Secondly, religious discrimination against a person is permitted in employment, partnerships and decisions of qualifying bodies if, because of the person's religious belief or activity, the person is unable to carry out the inherent requirements of the employment or partnership or profession, trade or occupation. That's a standard thing that goes in a lot of anti-discrimination legislation. So in disability discrimination, you can discriminate against someone on the grounds that they don't have sight because they want to be an air traffic controller. It's an inherent requirement of being an air traffic controller that you should be able to see. That's an obvious example. There's really no need for an inherent requirements provision in religious discrimination. I can't think of many cases where it would be an inherent requirement of a position that you either have or don't have a particular religious belief. The only example I can think of is chaplains. The problem with putting this in here is what is to stop a secular organisation making it an inherent requirement of a position that all its employees sign and support a statement affirming matters that contradict a particular person's religious beliefs. So here, in our code of conduct, we have a commitment to no proselytising, no speaking about religious faith. All our employees are required to promote the option of euthanasia. All our employees are required to participate in pride parades and fundraisers. Where is the protection for conscience? Inherent requirements in this broad thing is a very big and dangerous exception in this bill. Indirect discrimination, I described to you before, can be justified as reasonable. There is a list of factors to determine reasonableness. It's essentially a proportionality test. You weigh one against another. You weigh whatever the damage to a religious person's views is against what is trying to be achieved by the employer or the organisation. That is a reasonableness test as opposed to the necessary test under Article 18.3. Given the prevalence of codes of conduct, the reasonableness criterion for indirect discrimination is a big issue. I won't go through this. This is the Folau clause. It looks good on the surface. It says that you can't sack someone or discipline someone if you've got an employee conduct rule about their statements of belief, which would preclude them making a statement of belief, but it only works for all those criterion about statement of belief, and it only works for large employers who have a turnover over $50 million, and it only works if that large employer over $50 million would not suffer an unjustifiable financial detriment. So, a couple of questions. Why not just start with a proposition that an employer can't restrict an employee's ability to state their genuine religious beliefs in their own time? What's so hard about that? Start there and then carve out from there saying beliefs which incite hatred against the employer or the product or the co-workers or customers are out. This is an extremely complicated provision. Secondly, to the extent that we're going to let employers off the hook, even large employers off the hook, if there's an unjustifiable financial hardship, why on earth would you take account of the work of third parties? Why would you let a sponsor or a customer or a supplier to the business say, we don't like that employee's attitude, get rid of him, or we're pulling out contract? Surely, in this day and age, we're trying to reduce this sort of virtue signalling boycott, not encourage it. But what this law does is it encourages it by allowing the third party to exercise its lever over the employer to give the employer legal cover to sack or discipline an employee when the employer could not do that otherwise. My overall assessment of this bill is at best 5 out of 10. I think it's a reasonable first draft. It promises more than it delivers when you look at the detail. The government has tried to tackle some of these issues. I give them full marks for that. But there are too many big holes and too many ifs and buts that undermine good initiatives. If the government is willing to work at improving it, it could make it a good law. It could be a really good law, but it's well short of that now. And it's still only 70% of the agenda. Remember, we're still looking for parental rights in relation to schooling, the rules about schools and religious bodies managing their affairs, the protection of people from being forced to act or speak contrary to conscience, and protection from government action. Friends, I know I've gone on long, but I hope that has been a helpful assessment of what's before us at the moment. Thank you.